Silvana Reed, Assistant Public Defender, with and on behalf of Mr. Brown. Mr. Brown, could you please unmute and state your name for the record?
Aaron Brown.
Thank you. Your Honor, we have reviewed probation's recommendation. It is for jail time, and so obviously this is not something that Mr. Brown is looking forward to, but he does understand that is most certainly what the court will order. We would just like to ask, if possible, for him to be allowed to turn himself in on Friday, as he has a bit of time to serve in custody and would like to be able to get his affairs in order.
Is there anything you want to say?
I got prom next month. I've been here 17 years. I'll turn myself in after that. I'm not coming there Friday. I ain't missed a beat with my daughter. I've been here the whole 17 years. I can't turn myself in Friday. I don't want to go against your orders. I wish it could be another way. I'm not running from you. I had this thing going when I come to you. I turn myself in, but it will not be Friday.
Welcome, everyone. Today, we're diving into not one, but two wild Judge Simpson courtroom moments where defendants try to argue themselves out of jail and fail spectacularly. We're about to witness missteps, lies, and some jaw-dropping honesty that will have you questioning what goes on behind those courtroom doors. From a defendant trying to postpone turning himself in because of prom, to a bizarre, I only touch cocaine defense. Yes, you heard that right. We'll break it all down. Stick around, because by the end, you'll know exactly why Judge Simpson doesn't tolerate nonsense and why honesty really is the best policy.
You know, you can elect to do it your way, or you can elect to do it my way. That's going to be your choice. You decide you don't want to do an alcohol screening and assessment. You don't want to do anything. You continue to violate on the scram tether. So here's what we're going to do. It's a sentence of the court. I'll just order the $125 statutory fees. I will order 93 days in the, well, hold on a second. Is that the max on this? Yeah. I'll order 93 days. Well, hold on a second. What did he plead to? Operating one. Okay. I'll order 93 days, Washington County Jail. Credit to defendant to serve the balance. Defendant has told me he doesn't want to report, so we're going to do it this way.
I didn't tell you.
You report. I'm going to order that you don't get to choose your time.
I mean, can we work?
I'm going to order that you report to the Washington County Jail by 6 p.m. today. Failure to report will issue. There'll be a bench warrant issued for your arrest. That event bench warrant will issue with no bond. So you don't report 6 p.m. today, your choice. I'll send people to get you.
And here it is, the moment that will seal Mr. Brown's fate. He literally tells Judge Simpson he has no intention of following the plan his own attorney laid out. He tries to argue for a delayed turn-in because of prom. Yes, prom. But forgets that the court doesn't operate on a teenager's schedule. Judge Simpson is a compassionate judge, but he's also fair and firm. Ignoring instructions isn't just risky, it guarantees jail time. This is a textbook example of how overconfidence and poor timing in court can backfire spectacularly, turning a minor negotiation into an immediate sentencing nightmare.
Versus Isaac Ellington.
Assistant Public Defender Cosimo Bessi on behalf of Isaac Ellington. Mr. Ellington, could you unmute and state your full name, please?
Isaac Ellington.
Mr. Ellington, did you get a chance to review the PSI that I sent you to your email?
Yes.
Are there any corrections that you want to address?
Yes. A community pressing. I was never doing drugs. I got a friend, high school friend of mine. I've been trying to stop for him doing drugs. Hold on. Stop him for doing drugs and taking drugs from him. And the next couple of days, he passed away. I've been clean. I was dropped yesterday. I've been negative. I've been clean. I just lost a good friend of mine of the drugs, and he never woke up, and that's why I got the positive. Because I've been taking.
So you're saying you didn't do drugs?
No, I didn't do drugs. I didn't do drugs, I got one positive in April, and I'm like, in another way. I've been.
So you're saying positive for cocaine's, aren't you?
No, that's not. It's me because I'm taking it from my friend. He passed away now a couple days ago.
You took it from your friend, and then how did it get into your system?
Watch closely as Judge Simpson calmly lays out the options. He gives Mr. Brown a choice: follow the court's orders or face immediate consequences. This is pure judicial clarity in action. Notice how measured yet unwavering the tone is. No theatrics, just facts and authority. This is a masterclass in courtroom control. The judge doesn't just punish, he educates, showing exactly why following probation and court orders isn't optional. And the beauty? He leaves the responsibility entirely with the defendant. This is where many cases pivot: compliance versus defiance. And as we can see, defiance rarely ends well.
So you touched the cocaine, and then you tested positive.
Yes. Then
Oh.
yesterday I was negative.
Okay, is that the story? Is that really the story you're going to go with?
Yes.
You want to talk to your attorney before you stick with that story?
Yes, for real. I've been honest.
You don't, but do you want to talk to your attorney before that's the story you're giving me? Because this recommendation will change.
Mr. Ellington, I would advise you to accept what the recommendation is saying and ask the court to adopt that recommendation.
How about this cocaine, though? Because he's telling me that he didn't do it.
I would just ask the court to disregard Mr. Ellington's previous statement.
Well, I can't disregard it. That's like unringing a bell. I heard him.
Judge Simpson, I'm honest. I've been coming to court. I've been doing everything.
I know you're honest, but not an amoeba. You don't absorb things that way. So, counsel, you normally do this, but you want me to give you a breakout room to talk with him?
Yes, please.
And then we can talk about how the cocaine got there?
Oh my God.
Yes, please.
Yeah, I know.
Okay.
Now we move to Isaac Ellington, whose story could easily headline a courtroom blooper reel. He claims he didn't do drugs. He only touched them, and somehow that causes positive drug test. Judge Simpson, seasoned and sharp, immediately sees the holes in this logic. This is a moment of pure courtroom tension. Desperation meets scrutiny. The drama escalates as the defendant struggles to justify a clearly implausible story. For the audience, it's both shocking and oddly captivating, because we rarely get to witness the exact point where a defendant realizes her argument isn't just flawed, it's completely implausible.
Sir,
Mr. Ellington.
Sir, I don't doubt that part. I doubt the other part you just told me. Because, and I'm just going to lay it out there, you had a positive for methamphetamines on March 23rd. March 28th, you're positive. Hold on. You're positive for cocaine. You go away. You do have a negative test in between then. Come back April 3rd. You're positive for cocaine again. So, and he didn't go to the CCOP program. So this may change in any event. Sir, I'm just going to ask you, do you want to go into a breakout room and discuss this with your attorney prior to the court proceeding forth with sentencing? Because I'm ready to go, but I don't know that you.
Here's where the courtroom gets real. Judge Simpson offers a breakout room, a chance to regroup, consult with counsel, and maybe salvage credibility. Notice the subtle power play. The judge isn't just pausing for protocol. He's giving the defendant a final opportunity to choose honesty over self-delusion. This is a pivotal moment. The tension is palpable, and the audience can feel it. 2 weeks of violations come into focus, and it's clear this story won't end well unless Ellington steps up. It's a rare, inside-the-room look at strategy, patience, and the human element of the justice system, raw and unfiltered.
The amazing Mr. Ellington into a breakout room, and then we can bring them back momentarily. Court recalls the case. People versus Isaac Ellington.
Yes, Your Honor. Assistant Public Defender Costa Mubesi on behalf of Isaac Ellington. Mr. Ellington, could you unmute, please? State your name again.
Isaac Ellington.
Once again, Your Honor, we have reviewed the PSI, and Mr. Ellington does not have any. He would like the court to adopt the recommendation. Mr. Ellington, would you like to go ahead?
Yes.
Okay, so what about the cocaine? I'll wait.
I was just helping my friend out. I did it once or twice, Your Honor.
You did what?
I did it once or twice, Your Honor.
Finally, Ellington comes clean, or at least mostly. He admits to ingesting cocaine, though only after multiple failed stories. Judge Simpson's response is measured but firm. Probation, fines, and strict testing. What we learn here is crucial. Judges value honesty, even late, far more than elaborate excuses. The drama lies in timing. Had Ellington told the truth earlier, he might have avoided some of the consequences. This moment is a perfect demonstration of the justice principle. Accountability is rewarded, deception is not. And for us watching, it's a reminder that in court, clarity and truth save more than lies ever could.
Yeah, that's a much better story than the first one you gave me. Sentence of the court, 12 months probation, $655 fines and court costs, $360 probation oversight fees. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You know what? No, he's going to continue on his testing.
Oh.
Yeah.
Honor, I will be clean. I swear, Honor.
Well, here's what we're going to do.
No more.
You know, I hear you. So I'm going to give you a chance to prove yourself to me.
Okay.
Ms. Valera, I want him on testing, random testing through community corrections for the next 60 days. You're to complete the CCOP program or a comparable program. Now, when you do that testing, I'm just going to let you know. Any positives, you might as well just prepare for jail time. That's how I'm going to work this. I don't like people not telling me the truth, and you tried to start out not telling me the truth.
Okay, Honor.
You're to maintain employment with proof to probation. I'll order 365 days in jail. Credit 2. Sir, defendant will serve an additional 5 days for the bond violations to date, and then the balance will be suspended. You are ordered to report to the Washington County Jail by 6 p.m. So I got 360 other reasons why you don't want to use. We clear?
Yes.
Thank you. Report to the jail by 6 p.m. or bench warrant will issue with no bond.
Your Honor. Okay.
What? What do you want to tell me?
I was gonna tell you, can I do it I do it Friday. I could tell my job to hold my job and tell my kids I won't.
Ellington now tries to negotiate. Can he turn himself in tomorrow instead? The answer is a resounding no. Judge Simpson makes it crystal clear. Past actions dictate current outcomes. Here's the lesson for viewers. Defiance and dishonesty compound legal problems. What's fascinating is the human element. A defendant balancing life responsibilities like work and kids, yet undermining them with poor choices. Judge Simpson's approach is consistent. Fairness, accountability, and consequences. Watching this interaction, we see why courtroom authority isn't about intimidation. It's about maintaining structure and trust in the system and ensuring that every action has a proportional response.
But the problem is you came to me lying to me. I don't know right now whether or not, hold on. I don't know whether or not you're telling me the truth right now.
I am telling the truth because I'm at my
So
job.
the problem, hold on. The problem, Mr. Ellington, is when you start out like that, I can't trust you. I can't trust you that you'll be there Friday. I can't even trust that you're going to be there tonight. But I can tell you, if you're not there tonight, what's going to end up happening, I'm going to send somebody out to get you. Thank you.
Your Honor, I would just like to say that Mr. Ellington has expressed to me how concerned he is about keeping his job. And since him keeping his job is part of PSI's recommendation, I mean, if we could just get a day possibly or two and then have him report maybe by 6 p.m. tomorrow before the warrant goes out. Just to give him a small cushion to get his job straightened out.
No, not doing it. I told you what I'm doing.
Thank you, Your Honor.
He did what he did. Now I'm going to do what I'm going to do. That's just the way it works with me.
I will be there. I'm sorry.
And counsel, you know, if somebody had come to me and said, yeah, I accidentally used, or I shouldn't have used, I did this, then I'll deal with that. But if you come to me just straight up lying, and I'm telling you, I don't believe your story, and you continue to lie, and then I got to put you into a breakout room with your attorney, and now you're going to come back and tell me the truth? Really?
I'm not.
And now you want me to do something for you? Don't think so. I'm done.
I'm not lying.
What a roller coaster. Today we saw the stark contrast between honesty and defiance in Judge Simpson's courtroom. Mr. Brown's refusal to follow orders and Ellington's inconsistent stories highlight a universal truth. Transparency and accountability matter more than clever excuses. Judge Simpson's rulings were firm, fair, and consistent, proving that the justice system respects honesty but doesn't tolerate deception. If you found these cases as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping breakdowns.